General, I'd like to put aside the Lewis and Clark Fund for a minute, and I want to return to the direct injury argument, the Mohila is an arm of the state argument. Justice Sotomayor was pointing out, statutorily, Mohila has the right to sue and be sued. The state doesn't have responsibility for its liabilities, and the state has disclaimed any claim to the assets. Is that correct?
I would disagree with the last point. I don't think the state has disclaimed any interest in the assets.
So explain to me why. Because on the one hand, you have, in Missouri Statute 173.420, you have the last sentence says that nothing in these sections shall be construed to deprive the state and its governmental subdivisions of their respective powers over assets of the authority. But then in the next section, 425, it says, no asset of the authority shall be considered to be part of the revenue of the state. So which is it? I mean, because it would be hard to see how a win for the state would benefit Mohila or a win for Mohila would benefit the state if the assets are completely separate. You don't get any money out of it. Putting aside Lewis and Clark, because I'm not really interested in that.
So, Your Honor, to go to the second provision you read, 425, it says no asset of the authority shall be considered to be part of the revenue of the state within the meaning of a specific state constitutional provision. So I would then say that's only for a limited purpose. The prior provision that you read, where the state has preserved its authority over Mohila's assets, shows that any residual interest in Mohila's assets belongs to the state. So we cited the reciprocal casualty exchange case in our brief that shows that the legislature could abolish an entity like Mohila, and if it did, the money would come back to the state. So the state does have the ultimate interest in the property of Mohila.
If the state wanted money from Mohila right now, the state just wanted to pull assets out, say, because the state was going to make a decision to fund the Lewis and Clark Fund, does the state have the authority to do that?
Acting through the legislature, it does.
Okay.
And I think the Lewis and Clark Fund is actually a great example of that. So the Lewis and Clark Fund wasn't created until 26 years after Mohila began its operations. And at that point, the legislature came in and said, Mohila, you have to start giving this source of funding to the state. So the legislature can come in at any time and request money.
Do you want to address why Mohila is not here?
Mohila is not here because the state's asserting its interests. Mohila doesn't need to be here because the state has the authority to speak for them. And that brings me to—
Why didn't the state just make Mohila come then? If Mohila is really an arm of the state and all of this would be a lot easier, I mean, the Solicitor General conceded that if Mohila was here, Mohila would have standing. If Mohila is an arm of the state, why didn't you just strong-arm Mohila and say, you've got to pursue this suit?
Your Honor, that's a question of state politics, but we believe as a matter of law that the state has the authority to assert its interests. Under the factors in LeBron, under the factors that the Missouri State Supreme Court recognized in casualty reciprocal exchange, if it's a state-created and state-controlled entity that performs government functions, the state can speak for it regardless.
General, I'm thinking of an Arkansas versus Texas. It was significant in that case that Arkansas owned the land of the university. So it does seem that Missouri has created the separateness with respect to the liabilities of Mohila. What if, and I'll ask this to the other side, it's not really clear to me what happens to Mohila's assets. I mean, what if Mohila itself dissolves? There are no shareholders. I mean, does your answer change if, even though Missouri is not responsible for the liabilities, it does have an ownership stake in the assets of Mohila?
I think it's clear under state law, Justice Barrett, that Missouri doesn't have that kind of ownership interest in the assets of Mohila. And I would point in particular to Missouri Revised Statute 173.410. This is the provision that makes clear that Missouri cannot take the assets of Mohila and appropriate them. They don't go into the general treasury. It makes clear instead that those assets are under Mohila's exclusive control. So I think as a matter of state law here, we don't have anything like the Arkansas case that you just referenced. And as well, the flip side of that is the provision of state law that likewise says Missouri is not going to be liable for any agreements or obligations or liability of Mohila, so that if Mohila goes out there in the world and harms someone, the state's not on the hook for the damage. And that's another distinction from the Arkansas case where under state law there, it was clear that a suit against the instrumentality was a suit against the state itself.
Would you have the same position with respect to federal corporations? Like what about the FDIC or organizations like that? What if the agency didn't want to sue? Could the United States sue to protect the federal government's interests if the corporate identity was separate, like here?
No, I think that our principles would apply with respect to our own instrumentalities. We could, of course, sue to protect distinct rights and interests of the United States. And so respondents have cited some cases, for example, where an instrumentality entered into a contract on behalf of the United States in the name of the United States as its agent, and we had a contract right that we could enforce in our own name. Or there was another case that involved a statutory right in the tax context to offset, and the United States was permitted to sue on that basis because it had its own rights and interests. But we've never done what the states are doing here, and in the absence of any underlying contract right or statutory right or trust right, just asserted this all-purpose ability to blur the distinction between the sovereign and instrumentalities when they're separately incorporated in this way.
Justice Barrett?
2 questions, one on merits, one on standing. First, on the merits, do you agree that this administration and the prior administration had authorization under the HEROES Act to pause loan repayment obligations?
Your Honor, we're not challenging it in this case.
I know, but the question is, do you think it's within it? This kind of goes to the scope of waiver modify, right?
Yes, I think that so if I can go through the timeline to explain. So the first 7 days on March 20th, 2020, Secretary DeVos waived but didn't indicate what legal authority she was using. I have no way to assess that because I just don't know what authority she was using. Then Congress came in 7 days later and enacted the CARES Act. The CARES Act put a payment pause in place for 6 months. At the end of that 6-month period, Secretary DeVos extended it for 3 months. I think arguably that was a legitimate use of the HEROES Act because taking a congressionally created 6-month program and extending it for 3 months seems like it might be a modification. But now that we're 2 years down the road, we're beyond a modification. And not only that, the connection to the national emergency has become even more tenuous.
So your argument is that even assuming that Secretary DeVos initially had the authority to, and you're kind of just whiffing on the question about before the CARES Act was passed, right? But you're talking about after the CARES Act was passed, she arguably had authority under the HEROES Act to extend the pause, but that at some point as that time dragged on post the CARES Act, when the new administration came in, then it exceeded the authority to waive or modify?
Your Honor, it could have been the Secretary DeVos had 2 extensions. It could have been her second extension. I don't think it hinges on who the administration was. At some point, I think it goes beyond a modification, and the connection to the national emergency became too tenuous to maintain it.
So it's not that a pause is different in your mind than canceling the obligation to repay the principal. It's the, or I guess it's a combination of the distinction between a pause and a cancellation and then the temporal
Correct.
breach?
Correct. Because I do think there are significant distinctions between a pause and cancellation. I'll give you a few. The first is a pause maintains the status quo. Cancellation puts people in a far better. This cancellation puts people in a far better position. A pause keeps indebtedness from rising versus cancellation erases indebtedness. In addition, as I mentioned before, the connection to the national emergency. When you put a pause in place when the nation is still dealing with lockdown conditions, that is there's a pretty close connection between that and a national emergency. When 2.5 years down the road, the secretary, having much time to contemplate the situation, comes in and creates a debt forgiveness program for 95% of borrowers, the connection to the national emergency is too tenuous.
I understand. Second question's on standing. Could Missouri file suit to vindicate the interests of the city of St. Louis?
No, Your Honor, because when we look at the factors that we've cited for why MOHELA is a state-created and state-controlled entity, the leadership of the city of Missouri is not selected by the governor or by the state. They're selected at the local level.
Thank you. Mr. Connolly, what are the limits of your theory? Could someone who finished paying their loans off, right last year, sue because they were disappointed that they weren't included for reimbursement?
No, I don't think so, because there's no mechanism by which the Department of Education can write those borrowers a check. And so their injuries are not redressable. Here, there is a mechanism under which the secretary can forgive Ms. Brown's debts, forgive Mr. Taylor's debts, and that's the difference.
What about the Chief Justice's lawn care person who doesn't go to college, starts a lawn care business, but as the chief said, this person has some fairness concerns and feels like this shouldn't have happened and kind of level up or level down and wants to level down?
Sure. Again, the Secretary of Education has no power to give any money to that individual or do anything like that. And so even if he could come up with a concrete interest, it couldn't be redressable.
Could have persuaded him not to do it, would be, I take it with the fairness concern and the hypothetical the chief posed you. I think it would have been to say, well, this isn't fair. You're not doing this for me, so you shouldn't have done it for anyone. But you're not taking the position that that would be
No, he would
injury
not,
in fact.
because you have to have concrete interests, has to be particularized, can't be abstract, and so.
So it's not just the getting shut out of notice and comment, in other words.
Correct. These individuals have concrete interests. There was a $400 billion debt forgiveness program that was created, and the respondents have debts, and they're not being forgiven. And if it had gone through the proper process, negotiated rulemaking and notice and comment, we could have argued that our debts should be forgiven too.
Justice Barrett?
I want to ask you about universal vacatur. I just want to ask you one thing about the statutory language on waive or modify that I wonder whether it's an indication of the scope of waive or modify. So the Secretary has authority to waive or modify to ensure that affected individuals are not placed in a worse position financially in relation to that financial assistance, so in relation to their debt. So you agree, right, that we're not talking about a worse financial position generally. We're just talking about in relationship to the debt.
That's correct. That too often collapse, obviously, because if you are distressed financially, it might mean that you're having trouble paying your mortgage or paying your rent, buying your groceries, and paying your debt. But yes, the function of the HEROES Act focuses on your position with respect to your ability to repay your student loans.
So it seems to me that that language in relation to that financial assistance suggests that the relationship would continue. But the waiver or modification here severed the relationship to the debt so that it no longer exists. So why would that be consistent? I mean, doesn't the statutory language in relation to that financial assistance presuppose an ongoing relationship that might be modified, but not completely ended?
No, I think that would be reading in limitations that can't be gleaned from the text. What we understand the statute to be focusing on, and specifically looking at the subparagraph here that justified this act, making sure that student loan borrowers are not worse off with respect to their loans, that functions as a matter of their probability of being able to actually make their payments. And this actually relates to some of the questions that Justice Gorsuch was asking about better off, worse off. You know, imagine a student loan borrower, for example, who before the pandemic had her affairs entirely in order. She had a 0% chance of defaulting on that debt. But then COVID hit, her life has been disrupted, her job was disrupted, inflation is at record levels, she's having trouble making ends meet, and now she has a much higher likelihood of not being able to pay her student loans. In that situation, HEROES Act relief, if it were to operate even to completely eliminate her debt so she doesn't have an ongoing relationship with it, it would just restore her to her pre-pandemic relation insofar as her risk of default and delinquency. She was 0% before, and now she'll be 0% after. And so it doesn't inherently make her better off within the meaning of the statute.
Thank you.